Generally, a tenant in common who's in possession of co-owned property isn't liable to the other co-tenants for rent. However, a tenant in common may become liable for rent if that tenant ousts or excludes the other co-tenants from the property. In the 1994 case Martin v. Martin, the Kentucky Court of Appeals considered whether a tenant in common committed an ouster by occupying a certain portion of the co-owned property to the exclusion of the other co-tenants. In 1971, Charles Martin conveyed an undivided 1/8 interest in land that he owned in Pike County, Kentucky, to his son Garis Martin as tenants in common. Later, Garis transferred a 1/2 interest in the tenancy in common to his wife Peggy. In addition, Charles retained a life estate in the remaining 7/8 of the property for him and his wife Mary, with the remainder of the life interest transferring to Garis and Peggy upon Charles's and Mary's death. In 1982, Charles and Mary built a 4-lot mobile home park on the land, which they rented out. Garis and Peggy never paid Charles and Mary for construction or maintenance of the mobile home park, and Charles and Mary never shared in the rental income with Garis and Peggy. In 1990, Garis and Peggy moved their mobile home onto one of the 4 lots on the land, but Garis and Peggy never paid Charles and Mary rent for the lot. Subsequently, Garis and Peggy sued Charles and Mary in circuit court, seeking an accounting for 1/8 of the net rent received from the mobile home park lots. The circuit court granted the accounting, but required Garis and Peggy to pay reasonable rent to Charles and Mary for their occupied lot. Garis and Peggy then appealed the decision to the Kentucky Court of Appeals.